In this lecture, we'll discuss about Judges Inquiry Act 1968. So, the very question is that why it is in news. So, in the month of July 2025, the Union government introduced an impeachment motion to remove Justice Yaswant Verma, a judge of the Allahabad Highcourt, and previously he was in the Delhi High Court, and in whose Delhi residence sacks of burnt currency notes were discovered in March 2025. The government is reportedly reaching out to opposition leaders to build consensus for Justice Yaswant Verma's removal. So, it is in news since then. So, as according to the in-house committee report of the Supreme Court by Chief Justice of India, the then Chief Justice of India, so the in-house committee formed by the then Chief Justice of India, Justice Sanjeev Khanna, reportedly indicted Justice Verma, observing that the allegations against him were credible and warranted an impeachment. Justice Verma reportedly did not heed the very advice of the then Chief Justice of India, Justice Sanjeev Khanna, to resign. So the Chief Justice sent a letter to the President and Prime Minister of India to impeach Justice Verma. Here, as reported in Times of India, would like to discuss the manner in which the government is approaching the removal of Justice Verma is having several troubling factors such as reported in Times of India that we found the government is creating the impression that it is authorized or has the jurisdiction to initiate the removal of a judge which is not in a true sense as provided under the Judges Inquiry Act 1968. Only members of Parliament are authorized to sign a motion to remove a judge. So, on the motion, once it is passed, then signed and submitted to the Speaker or the chairperson, as the case may be, the decision to accept or reject it lies with the Speaker or the chairman. And as regarding the report, or as we found in Times of India, the government believes that there is no need for a committee to investigate allegations against Justice Verma under the Judges Inquiry Act 1968. As an in-house inquiry committee has already submitted a report. So, to understand the very removal procedure, we will discuss about the constitutional provisions for removal of judges of Supreme Court and High Courts as provided under Article 124, Clause 4, then Article 125, Clause 5, and Article 218 of the Constitution of India. So, for the very procedure of impeachment, we would like to discuss the constitutional provisions. So, as per the constitutional provisions for impeachment proceeding, and for the very removal motion must be signed by 100 members in case of Lok Sabha, or the House of People of 50 members in case of Rajya Sabha, or the Council of States is to be given to the Speaker in respect to Lok Sabha and to the Chairman in case of Rajya Sabha. The motion is admitted then a three-member committee to investigate into the charges as constituted. The committee finds the judge to be guilty of the charges of misbehavior or incapacity. The House in which the motion was introduced can take up the consideration of the motion, and it requires a special majority, the majority of total membership of the House and majority of not less than two-thirds members present and voting. Once the House in which removal motion was introduced passes it with special majority, it goes to the second House, which also has to pass it with a special majority. After the motion is passed, an address is presented to the President for removal of the judge. The President then passes an order removing the judge. So, in that connection, would like to discuss the very provisions of the Act in relation to the removal of the said judge. So, in that connection, we would like to discuss the provisions relating to Section 3, subsection 2, into form a committee to investigate, and regarding the very members of the committee and the inquiry procedure and submission of the report of the inquiry committee. So, the understanding by the government here appears incorrect and could undermine not only Justice Yaswant Verma's right to a fair procedure, but also the 1968 Act as a legislation deriving its strength from the Constitution. The government is mistaken in conflating an in-house inquiry with the inquiry contemplated under the provisions of the Judges Inquiry Act 1968. The two inquiries differ not only in their mandates and powers, but also in their purpose. The government has not shared a copy of the in-house report as sent by the then Chief Justice of India, Justice Sanjeev Khanna, with the members of Parliament who under the law are authorized to sign the motion to initiate the removal of a judge. In the absence of the report, the members of Parliament cannot form an informed decision on whether to initiate removal proceedings against Justice Yaswant Verma. They cannot be expected to act without evidence. So, the constitutional provisions as regarding removal of judges as provided under Article 124, Clause 4, it provides that a judge of the Supreme Court shall not be removed from office only until and unless two steps are followed. First, each house of the parliament with at least two-thirds members present and voting have by a majority of total membership presented an address to the president in the same session. That judge has to be removed on the grounds of proven misbehavior or incapacity. And second, the president passes an order regarding the very removal. After this address and as provided under Article 125, Clause 4, 5. Further, it provides that Parliament may by law regulate the procedure for the presentation of an address and for the investigation and proof of the misbehavior or incapacity of a judge under as provided under Article 124, Clause 4. It is important to note that Article 218 of the Constitution directs that the provisions of Articles 124, Clause 4 and Article 124, Clause 5 shall also apply to High Court judges. Thus, the procedure for removing a judge of the Supreme Court or a High Court is same and as provided the Judges Inquiry Act of 1968 derives its authority from Article 125, Clause 5 of the Constitution. It regulates the procedure for investigation and proof of the misbehavior and capacity of a judge of the Supreme Court or a High Court. The presentation of an address by Parliament to the President and matters connected therewith. So the very question is whether the Speaker or the Chairman, as the case may be, can overlook the very mandate of the Justice Inquiry Act 1968, which mandatorily provides for a committee to investigate allegations against a judge. Additionally, the question arises whether Justice Yaswant Verma is entitled to the fair procedure as provided under the Act of 1968, so as provided under Section 3, Subsection 2 of the Judges Inquiry Act, mandate the formation of a committee to investigate the grounds on which the removal of a judge is sought. This process is initiated when a motion to remove the judge signed by 50 members, as in case of Rajya Sabha or the Council of States, are 100 members in case of the Lok Sabha or House of People, is admitted by either the Speaker or the Chairman, as the case may be, on what basis an MP is expected to sign the motion to remove a judge when the Prime Minister's office, which received the in-house report from the then Chief Justice of India, Justice Sanjeev Khanna, which was not made public. So, now what exactly requires that the very case, as per the reports of Times of India, MPs or members of Parliament are initiating the removal process before an in-house inquiry committee, although they are entitled to do so under the very Judges Inquiry Act 1968. So, the very question is that the likelihood of the presiding officer rejecting the motion is high. Coming to Judges Inquiry Act, the committee under the Act consists of three members, of whom one shall be chosen from among the Chief Justice and other judges of the Supreme Court, and the second one shall be chosen from among the Chief Justices of the High Courts, and the third one shall be a person who, in the opinion of the Speaker, or as the case may be, the chairman of Rajya Sabha, is a distinguished jurist. So, as per the very provisions, the very in-house committee is solely concerned with fact-finding. It cannot examine or cross-examine witnesses on oath, and there can be no representation by lawyers, as the very in-house committee report submitted by the then Chief Justice of India to the President and the Prime Minister of India. In contrast, the committee formed under Justice Inquiry Act 1968 is required to frame definite charges against the judge on the basis of which the investigation is proposed to be held. Furthermore, the committee must provide the judge with a reasonable opportunity to cross-examine witnesses, adduce evidence, and be heard in their defense. And at the very conclusion of the investigation, the committee is required to submit its report to the Speaker, or as the case may be, to the Chairman, or where the committee has been constituted jointly by the Speaker and the Chairman, to both of them stating therein its finding on each of the charges separately, with such observation on the whole case as it thinks fits. And the very provision under Section 5 of the Act, that the very committee is enjoying the power of a civil court, the very section, that is Section 5 of the Justice Inquiry Act of 1968, confers powers of a civil court upon the committee, which includes power to summon and enforce the attendance of any person and examine him to an oath. It also requires the discovery and production of documents, further to receive evidence on oath, then issue commissions for the examination of witnesses, and such other matters as may be prescribed. The in-house procedure provides no such power to the in-house committee, though it says that the committee can devise its own procedure consistent with the principle of natural justice, and as per the provisions of Section 6, which provide the very pending proceedings which would lapse. So, in particularly, Section 6 states that if the report of the committee contains a finding that the judge is not guilty of any misbehavior, or does not suffer from any incapacity, then no further steps shall be taken in either House of Parliament in relation to the very report, and the motion pending in the House or the Houses of Parliament shall not be proceeded with. But if the report of the committee contains finding that the judge is guilty of any misbehavior, then the motion shall together with the report of the committee be taken up for consideration by the House or Houses of the Parliament. Then the motion is debated and voted. If adopted, then misbehavior is proven and an address praying for removal of the judge is presented to the prescribed manner to the President of India by each House of Parliament in the same session in which the motion has been adopted. So the Judges Inquiry Act 1968 is self-contained statute that provides for a legal framework for removing a judge as mandated by the Constitution. This procedure cannot be undermined by an in-house committee report as it was sent by the then Chief Justice of India, Justice Sanjeev Khanna, to the President of India and to the Prime Minister of India, which lacks the very statutory authority as provided under the Judges Inquiry Act of 1968. The in-house procedure as available on the Supreme Court aims to address concerns surrounding members of the higher judiciary not being accountable for their conduct. It also protects judges from false or frivolous complaints. However, it does not regulate the removal of a judge. So, in that connection, would like to discuss the very judgment of Supreme Court in the important leading case Indira Singh versus Register General of Supreme Court of India in 2003. The Supreme Court observed that Chief Justice of India's authority to conduct an in-house inquiry derives solely from the moral or ethical consideration, and which is not having any statutory authority. And in particularly, we found the very procedural differences in between the in-house committee procedure and the very inquiry report. So, a clear comparison of the Judges Inquiry Act and the in-house procedure reveals the very distinct purposes, scope, and origin. So, as we found under Article 125, Clause 5, the in-house procedure is not a law under the Constitution. While an in-house committee report may carry some moral weight, it cannot replace a report submitted under the Judges Inquiry Act of 1968. Further, the in-house committee headed by a Chief Justice of a High Court lacks the authority to take evidence on oath and serves only a fact-finding body of the Chief Justice of India. In contrast, the committee formed under the Judges Inquiry Act 1968, chaired by the Chief Justice of India or a Supreme Court judge and including a distinguished jurist, has extensive powers, including the right of the judge consent to cross-examine witnesses, further denying the procedure outlined in the 1960 Act would violate Justice Verma's fundamental rights to a fair process as provided under Articles 14 and 21 of the Constitution. The report considered, debated, and voted on in a parliamentary motion when a judge is found guilty is that of committee constituted under the Judges Inquiry Act 1968 is not an in-house committee report. As we found, for instance, in the case of Justice Sumitra Sen, a committee was formed under the 1968 Act despite an in-house committee's findings and a letter from the then Chief Justice of India, Justice K.G. Balakrishnan, recommending Justice Sen's removal. Similarly, in the case of Madhya Pradesh High Court Judge Justice S.K. Ganguly, a committee under the Act was constituted, notwithstanding an in-house probe. So, here the Speaker of the Lok Sabha and the Chairperson of the Rajya Sabha cannot bypass the mandate of the Judges Inquiry Act 1968. It is hoped that they will strictly adhere to its provisions. This would mitigate the very possibility of a challenge to Justice Verma's removal process in the court which could delay his removal as a judge. So, in the very present case, also makes a compelling case for amending the in-house procedures, where we found inheriting wrong communications in the House report to the Prime Minister and President, for that matter, the President, and urging them to initiate the removal of a judge. The irony lies in the fact that the members of Parliament who are authorized to initiate removal proceedings and the votes of the members of Parliament are crucial for a judge's removal are not provided with a copy of the in-house report as submitted by the then Chief Justice of India, Justice Sanjeev Khanna, to the President and to the Prime Minister. And in concluding, we found another thing, a similar situation occurred in the case of Allahabad High Court Judge Justice N. Narayan Shukla, where the in-house report remained undisclosed even as the Chief Justice of India sought his removal based on the in-house committee report. However, the government neither shared the report with MPs nor took any initiative to approach them to facilitate the judge's removal. So, these are the pertaining issues and the most vital and important issues now revolving around the Parliament and the legal fraternity in regards to removal of Justice Yaswant Verma, at present a judge of Allahabad High Court, and previously he was a judge of Delhi High Court. And the very in-house committee report submitted by the then Chief Justice of India, Justice Sanjeev Khanna, for his removal, submitted to the President of India and to the Prime Minister of India and the very government, without sending all the copies of the report to the members of Parliament and without following the provisions of Judges Inquiry Act 1968, initiating the very removal of the judge in Parliament in both the lower house of parliament and the upper house of the parliament of India.